I filed a motion for costs and District Judge Chuck Weller denied that motion. In response, I filed a notice of appeal and the Court of Appeals said,
Sorry, Hans, wrong guess.
Let's find out where he went wrong. Alex here with part 168 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the Court of Appeals decision to reverse Judge Chuck Weller's decision in my child custody case. Now, at this point in time, he's already gone anyway, so you could just say that this was my parting gift to him after the fact. But indeed, I mean, the mindset is hard to describe with words what it feels like. Because a lot of times, I think what this comes from is you just assume that the government's doing everything correctly. You just assume that the judge knows what he's talking about. You just assume that the law's being applied correctly and that for whatever reason, people don't believe you. And then at this point, you get an order from a higher court saying, no, your judge screwed up. And you're like, hold on a second, I was right. They weren't even applying the law correctly. So, I mean, we're not even dealing with he said, she said, my evidence, her evidence, witnesses. It's just the law and their inability to apply it correctly. And this is just the first appeal in this series that you guys are going to go. The first appeal that I want a reversal on that you guys are going to see. You're going to see another two, this time against my new judge, that's District Judge Bridget Robb. But that's for a later time in the My Docket series. For now, I think we seriously are just going to have to go straight into what the Court of Appeals has filed. Here we have the Court of Appeals order of reversal and remand. We go into standard introductory paragraph where they identify this as a proper person appeal from a district court post-judgment order denying costs in a writ proceeding. If you want to learn more about post-judgment, I think I have a video on that topic actually titled Post-Judgment Proceedings. And I also have a video on the topic writ petitions, which will explain to you what a writ proceeding is. They will go ahead and identify District Judge Chuck Weller, that he is operating from the 2nd Judicial District Court, which is mainly Washoe County. I think that might be only Washoe County, not sure. And then we also have the fact that he is in the Family Division. In the District Court, I was granted a writ of mandamus directing the government to disclose my ex's confidential address. My ex was a participant in the fictitious address program. After the petition was granted, I moved for costs to be imposed against my ex under the law, which requires an award of costs, quote, to the prevailing party against any adverse party against whom judgment is rendered, unquote, in a, quote, special proceeding, unquote. In the motion, I waived any right to seek costs against the Secretary of State. The district court agreed that costs were required to be awarded under the statute, but concluded that there was no basis to find that my ex was an adverse party within the meaning of the law. Thus, because I had waived my right to recover costs from the government, the district court denied the motion for costs. Guys, if I didn't waive my right to collect costs from the government, you would have found another reason to deny it anyway. Next paragraph here. In a legal proceeding, an adverse party is one, quote, whose interests are opposed to the interest of another party to the action, unquote. I love how they just school him. Here, my interest-seeking writ relief was to have my ex's address disclosed to me, while the Secretary of State was the party that was actually required to disclose my ex's address through the writ of mandamus issued by the district court. It was my ex, not the government, who had any interest in maintaining the confidentiality of her address. And then he goes ahead and cites my case, Falcone v. Secretary of State. All right, as my ex's interest was opposed to that of myself and judgment was entered in my favor, They, the Court of Appeals, conclude that the judge, District Judge Chuck Weller, erred in finding that my ex was not an adverse party against whom judgment was rendered. This is like such a no-brainer of a case. In denying my motion for cost, the district judge also found that my motion was not properly supported insofar as I had not submitted a receipt for payment of the specific amounts that I have requested. You know what I love about this is he just invents this out of thin air. Let's see what the Court of Appeals has to say about his invented requirement. Falcone, however, filed a verified memorandum of costs. Spoiler alert, that's what the law says you're supposed to do. That declared under penalty of perjury that the requested costs were actually and necessarily incurred in this case, and that explained the grounds for the requested costs. Let's see here. Nevada Revised Statute 18.110, blah, blah, blah. Yet another statute telling him what to do, yet another statute that this judge and the next judge would ignore. I have also filed supporting documents that further demonstrated the grounds for the costs that I was requesting. Under the circumstances presented in this case, they conclude that the documentation filed by me was sufficient to demonstrate that the costs were actually incurred and to permit the district court to determine whether the amount of costs incurred was reasonable, explaining that a party must provide documentation, etc., etc. Thus, for the reasons discussed herein, the Court of Appeals concludes that the district judge, Chuck Weller, erred by denying my motion for costs. And then they cite the law. And then they cite another law. The subject is, and this is basically them going into what the meaning of must is. And I think this is pretty obvious to most of us here, but must expresses a requirement when the subject is a thing, whether the verb is active or passive. Like seriously, going into the grammar of the word must. It's a completely different sort of analysis when you deal with the appellate courts than when you deal with the family courts. Anyway, they have basically finished it off with ordering that the judge's denial of my motion for costs is reversed, and they remand this back to him for proceedings consistent with their order. And this decision was unanimous, which means all three of the judges ruled in my favor. There was nobody that had a different opinion. Okay. Memorandum of costs. Here we have the memorandum of costs that I want on winning this appeal. So first I get the costs in the lower court that he didn't give me, and now I get a few more dollars. And I go into all of the costs that were associated with mailing and everything else. And then we have, oh wait guys, if you want to learn more about what constitute costs, please watch the video on the topic. It's titled, I think it's titled Attorney Fees and Costs. And I go into what the definition of that is and a few more details that are important, I think. Then we have Rule 525, I'm used to Rule 5 from the Rules of Civil Procedure. In the appellate court, it's Rule 25B. It's a different rule, but it is for the most part the same. And I know that those rules changed recently, so I can't say for sure. The Rules of Civil Procedure changed within the last year. Anyway, notice of entry of order. This goes into me notifying my ex that the order of reversal and remand was entered in this court. Hey guys, I don't think that you even need to do this. If you watch my video on the topic notice of entry of order, you will learn that it appears to me that this requirement comes from the Rules of Civil Procedure and that it specifically ties into the timelines and deadlines to file an appeal. There is nothing like this in the Rules of Appellate Procedure, and obviously that whole time limit thing wouldn't apply because you're already in the Supreme Court / Court of Appeals. So my suspicion is that I should not have filed this notice of entry of order, and if I could go back in time, I wouldn't file it. Well, upon confirming that that's correct, I wouldn't file it. Next we have, and guys, if you want to learn why in detail, don't just trust me, please watch my video on the topic notice of entry of order. Anyway, next we have a notice of change of address. This is a document where I am indicating to the court that I have moved. And if you want to learn why this is such an important document to file, please watch my video on the topic notice of change of address. I cannot understate how important it is for this document to be filed when you move. It impacts whether or not you get future documents through the mail. We also have another Rule 25B certificate of service. Next document is the memorandum of costs and disbursements, and this is actually issued by the Supreme Court Clerk. So this is their way of confirming to me that I'm entitled to additional costs on appeal. I think that's everything. Going into the next document, we have the remittitur, and this is, I think I mentioned what this is in the video filing an appeal. If not, I'm going to go ahead and let you know now. The remittitur is issued from the Supreme Court down to the lower court clerk, letting them know that the Supreme Court is done with everything that they had to do with that appeal, and that jurisdiction of the case is transferred back to your lower court judge. If it's not talked about in the video filing an appeal, it might be, actually, for sure it's talked about in the video jurisdiction divested on appeal. Both of those videos are great, guys. You should take a look at those. And then we have the certificate, clerk certificate, and the judgment entered by the Court of Appeals. That's it. Going into the aftermath, I filed 3 documents, and they were free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney for this appeal. And so for this appeal, not having an attorney, I incurred $0 in costs. My ex had an attorney, but she didn't participate in this appeal at all. So I'm going to say that, you know, at the beginning she had an attorney, and then at the end, when this disposition was entered, she didn't have an attorney. But it doesn't matter, because I don't think she would have sent it to a lawyer for review at this point. So I don't think she would have incurred any attorney fees on reviewing this order. So I'm going to say $0 in attorney fees for my ex. The government didn't file anything, so they incurred $0 in costs. They would have reviewed the order of reversal and remand, even though it didn't apply to them. They don't know that until they read it. And so until they read it and find out that it doesn't apply to them, they're not going to, you know, stop and do their due diligence. So I think for something like this, where clearly they didn't have to do anything about it, it's going to be 15 minutes in attorney fees for the government, which at the rate of $250 comes to $62.50 in attorney fees for the government. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.